Now I find that other honorable members who do not happen to be lawyers keep on advancing such attractive arguments that we get charmed and we keep on listening. And particularly when those honorable members happen to be lady members and they make such beautiful speeches, then the house goes on and on. Half an hour discussion may become half a month discussion. So, what I was saying was, I got these figures worked out and found that by applying this yardsticks of 650 cases per judge, the following is the requirement. We know that in these high courts so many cases were instituted in 1986. Therefore, if you apply the yardstick of 650, what would be the normal strength which would be able to cope up with as many cases which are being instituted every day as would get disposed of the same day so that arrears would not go on increasing. In fact, there would be a decrease in the arrears. Then, what would be the strength? And what would be the strength when the arrears go on decreasing? I found you need extra strength for all this by working out at 650 cases per judge. Take for instance in Karnataka High Court, the strength is 14 permanent and 3 additional. The total strength is 17, and I find that by applying this yardstick of 650 cases per judge, the number of cases which were instituted in the High Court in 1986 would require 33 judges. Whether they are permanent or additional, that does not make any difference because that is only a matter of approach. Otherwise, they dispose of the same quantity of work. So, a strength of 33 judges would be required to keep pace with the institutions every day. If you want to liquidate the arrears, first of all, the strength of 17 must be raised to 33. Moreover, you will have to have some extra strength in order to clear the backlog. It is a question of calculation how many judges you should have for how many years in order to clear the backlog, by which time that the backlog would be cleared. For clearing the backlog, some extra strength would be required. And now it is true that before the constitution was enacted, most of the high courts, except some, did not have this very useful writ jurisdiction. At that time, whatever the government did was final because so many acts were passed with the result, right or wrong, whatever the government did or said became final. Sir, I rise to support the bill as it has emerged from the Joint Committee, but while doing so, I wish to make some observations gradually and also in respect of certain clauses. The objects of the bill as originally introduced have been enumerated like this: that a litigant should get a fair deal in accordance with the accepted principles of natural justice. Every effort should be made to expedite the disposal of civil suits and proceedings so that justice may not be delayed. The procedure should not be complicated and should, to the utmost extent possible, ensure fair deal to the poorer section of the community who do not have the means to engage a pleader to defend their cases. I wonder whether any of these three objectives will be achieved by this bill. Let us not flatter ourselves that this amending bill, as it has emerged from the Joint Committee, will be able to achieve any of these objects. The Code of Civil Procedure is a complicated thing. It was framed in 1908. We have streamlined it here and there. We have removed some hardship here and there and codified some of the legal decisions, and we have removed certain conflicts in decisions. But that does not mean that the litigant is able to get speedy justice or justice at less expenses. Let us be clear about it. I do not blame anybody, but by the civil procedure as it stands, none of these objects can be achieved. I am glad that some of the provisions which have been introduced are really good. They have removed the doubts and conflicts in respect of judicial decisions which had prevailed, each high court giving a different decision about a particular matter that has now been set at rest. For instance, in section 11, there was a conflict of judicial decision whether the decision of a court with limited jurisdiction can operate in a subsequent proceeding between the same parties in a higher court. There was a conflict of decisions, and now it is set at rest by saying that the decision of the lower court within limited jurisdiction will operate in a subsequent suit between the same parties in a court with higher jurisdiction. Secondly, it is also made clear that this principle applies to execution proceedings. I would like to say that it is a good improvement.